Hello! Happy Wednesday. I'm Ali. I have the law office of Alexandria Goff. I'm in my backyard today. It seemed nice. There's a nice tree there. I have Oliver, who may or may not cooperate with me, so hopefully I can get to all your questions without him deciding to revolt and go do something else. He's a little awake actually, which I was hoping he'd be asleep for. Oh well. Anyways, you can see the backyard. There's a few horses there. Our lovely neighbor has these great horses we get to see. And then, of course, there's Henry's, we call it the sandbox, which is actually an old arena. Hold on, kiddo. Okay, let's go ahead and get started. So the first question that I get this a lot, and I got it most recently, is what estate planning documents do I need to have? Which ones are essential? And when we talk about an estate plan, a lot of people think that means like a fancy trust or, you know, people with millions and billions of dollars. And well, those people need estate plans too. A lot of the documents that we actually need are fairly simple and can be found online or can be drafted pretty quickly, but they're all really sort of necessary because they work together. So the first is, so if you're meeting with an attorney or you're wondering, you know, is my estate plan quote unquote complete? The first thing is a durable power of attorney for finance, which would say, if you're incapacitated, here's who could make financial decisions for me. Next up is the Advanced Healthcare Directive, which does essentially the same thing, but for medical decisions. If I'm incapacitated or I'm in a state where I can't make medical decisions, here are the people who get to make those decisions. And those people can be different. You don't have to have the same healthcare agents as you do financial agents, and oftentimes people choose different agents because people have different strengths, so consider that. The complement to the Healthcare Directive is a HIPAA release in California. I like to have that as a separate document so that you can have people know about your medical decisions or conditions or treatment options without them having any decision-making authority. Hey Miriam, thanks for joining us. After that is the trust. Generally speaking, most people in California get a trust because probate is so awful. The next question is actually what's the difference between a trust and a will, so I won't go through that now, but a trust is one of the key components that we use in California for estate plans to avoid probate and transfer assets and deal with incapacity. Then there's the will. Yes, in California, you would have both a will and a trust, and I'll go over why. And then an assignment of property. A lot of times people forget to fund their trusts. So we have a document that we just call an assignment of property, personal property. Lots of lawyers call it different things, and essentially says, if I left anything out of my trust, I intend it to be in there. It is really important that you meet with your attorney to find out if that is an appropriate document for you. If you have multiple trusts or you have a blended family, you might not want all of your assets to go into one trust. Let's see. Oh yeah, and then if you have minor children, the guardianship nominations, that can be a standalone document, that can be in a will, and that nominates who would make decisions for you, for your children actually, who would raise your children, make financial decisions for them, and who would actually physically care for them, take them to the doctor, decide where their school is, all of that jazz. So that is essentially the estate planning, I call them the estate planning essentials. If you have a business, obviously we'd want to talk about what your needs are there for businesses. Hey Kim, thanks for joining us. And then schedule of assets is great. It can be necessary for your trust, but also just can be really helpful as a roadmap for your trustee. Because let's pretend you're not here anymore and someone has to go ahead and administer your trust. As the estate planning attorney, I say, well, look at the schedule of assets. And if it says all of my property, well, that's not super helpful because what does that mean? Hi, Casey. Thanks for joining. So in addition to the schedule, it's good just to have a list of what your financial documents, what's in the trust, what's not in the trust. That's one of the things that we do that's a little bit different is we do a schedule of non-trust assets. Again, let's say you don't want everything to be in your trust or you have an IRA and it has a beneficiary designation. Really important to let people know where they can find that information. So that's the estate planning essentials, the things that you should probably have. The second question, I get this, I think every estate planning attorney gets this in California. It's a pretty frequent question and it sometimes can be confusing, is what is the difference between a will and a trust? So a will says, here are the people I want to make decisions for me and here's where I want my stuff to go. That's sort of the simple version of that. The problem with the will is it doesn't avoid probate. It means that your estate, if it's over a certain amount, here in California it's 166.50, I think, recently changed. Your estate would have to be administered with court supervision. And I can tell you right now, the courts are, one, not open. And when they are opening, they're going to be so delayed that unable to even get a hearing to have your estate be open so someone could administer it, which means pay creditors and marshal all your assets and sell them and then distribute them, is going to take far longer than it used to. I used to say, if you're lucky, you're done in a year. And now I'm going to say you'll probably be lucky if you're done in 2, depending on what county you're in. So the will gives instructions, but it doesn't avoid probate. So that's really the benefit to having a trust. The trust is great because it can step in if you are incapacitated. Someone can manage your finances if you're incapacitated. And then after you pass, your trust can be administered without court supervision. I call it a private family matter, as long as no one's fighting, of course. There's always that. I'll do that question a different day. What happens if my family fights? So the purpose of the trust is really to kind of keep everything private. We don't have to publish in a newspaper. We don't have to let the entire world know that your estate is being administered and who your beneficiaries are. It can be really what it's designed to be as a family matter. So those are the 2 questions I had for this time. If you guys have any other questions, please let me know. I'm happy to answer them on the next Facebook Live. It'll be Wednesday at noon. I will remind you, since I am an attorney, this is not legal advice for your specific situation, but it's designed to be some information that you can either contact an attorney and talk to them, or do your own research and find out what else might be needed. Oh, I have 2 other questions. Okay, so the first one is, hold on, I have to open that thing. Okay, I'll do Casey's first. What do you recommend for a young person who wants to help their parents plan for the future, specifically when the parents don't want to work on those details? Yeah, I totally feel you. And I get that question a lot too, because really estate planning is not for the people who are alive. It's for the people who are left behind. So one of the things I might recommend in talking to parents, or really any loved ones who, kind of need this, which I think is everyone, but let's go with the parents for now, is just having a conversation about what would your end of life look like? What are your wishes? What are some things you'd like us to know? Maybe sort of ease into that conversation. I do also have a lot of blog posts on my site that could be shared with family members so that you could say, oh, I read this kind of interesting source, and see if they might sort of take it from there, because you certainly can't force anyone to get an estate plan. But you might be able to open that conversation, and maybe if they found out how awful probate is, they might be willing to have a conversation with an attorney, or at least with a family member, to get that going. Another thing that sometimes works is if you do your own estate plan. Hey, I just did my estate plan. I know I don't have a lot, but I got my healthcare directive and my power of attorney. And the lawyer said it's really important to make sure that blah, 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 fill in the blanks, or hey, I saw this was really cool. So that might be a way to sort of open up that conversation with family members. Hopefully they listen, and hopefully they go ahead and get something in place before it's too late, because if not, we could be risking conservatorship, which is a court supervised process while they are incapacitated, and then a probate, which is, it's just so much money to lawyers. It's really not necessary. And if we can avoid it, we try to. Okay, next question is, what about DIY estate planning? Yeah, you can super do this on your own. You can get your own estate plan. You could go to LegalZoom, and you could go to whatever online course they're selling, and you could go to Staples and get their estate plan in a box. I just can't recommend it because of the problems I've seen. I do litigate. I often take the cases where things didn't go well. And when people trying to plan their own estates, oftentimes they cause more problems than they actually solve. So while it looks like you're saving money, and you oftentimes do, you can pay almost nothing for an estate plan online. You really are just causing a lot more problems, because like I talked about, a conservatorship, which is if you're incapacitated and you don't have a healthcare directive and you don't have a power of attorney, I recommend costs about $10,000 for the first year, if nobody's fighting, to get one of those in place, because it's so time intensive and there's all sorts of stuff involved in that. And then on top of that, you'd add the probate. And so if you got a trust done for, let's even say it was $6,000, which is a super high estimate. Most estate plans don't need to be $6,000, but let's say it was. You're still saving $4,000 plus the probate, which is another $20,000. I'm just making up numbers at this point. So just know that you get what you pay for. And I would say for most people, you need a sort of comprehensive estate plan drafted by an attorney. But let's say you don't have any assets, you have beneficiary designations on everything. You know what? Make sure at least you get a healthcare directive and a power of attorney. Those documents you can get for free online. We're actually doing a workshop coming up for healthcare directives at a really, really low rate. I'll have an announcement on that probably next week, so that people can get their healthcare directives done, because really you have to have that done whether you have $1 or $1 million or $100 million. So hopefully that answered the question of DIY estate planning. I also think I have a blog post on, DIY nightmares and, or people who died without estate plans. It can be all sorts of messy. So, okay. Oh, hi Samantha. Sorry I didn't see you there. The comments are fun. Thank you for joining me. I really appreciate our time together. It's nice to get not out of the house, physically out of the house, mentally out of the house, and answer some fun questions, get people some help even though I'm not in the office. And say hi to Oliver. Can you say hi, Oliver? Yeah. He's almost waking up, lifting his head, doing fun things like that. So yeah, please feel free to share this with your friends. The office is open. We're practicing social distancing and taking care of our clients as best we can, hoping we can get them taken care of and they can ease the burden in their brain so they're not worried anymore. That's sort of our goal, is to make sure people don't worry. Oh, thanks, Samantha. He's got a cute house. So maybe I'll get Henry, although I'll tell you, toddlers are, notorious for not following directions. So I may or may not bring him next time. So until next Wednesday, I will see you all later. Talk to you. Bye.